Welcome, my name is Owen Welling with Gun Rights Across America, Washington State. I'm here today to give you a quick presentation on gun rights and minors and what we believe is going to happen with those rights that they currently have under the RCWs if I594 passes. As we know, minors and guns, parents take a lot of responsibility in teaching their children, and they take a lot of pride in passing that culture on to their children as well. I594 is 18 pages, as it's well known, but it's because it practically guts a lot of these segments in the RCWs, and it replaces them with what's listed in a 594. We believe this will provide a chilling effect in the current culture and prevent a lot of that information transfer and culture transfer to future generations. So currently, minors with firearms in RCW 941042, basically the minors under 18 can, once they have a hunter safety course and once they have a hunting license, they can go hunting just about anywhere. They can practice just about anywhere that it's lawful for them to be, whether it's a firing range, whether it's a competition, or whether it's private property. Okay? When they go hunting, they can go anywhere that hunting is lawful as long as they are, and they can go unaccompanied as long as they are 14 and they have their license and their hunter safety permit, which they can't get their license without having their hunting safety permit once they're 14. So currently in Washington State, you may not have a driver's license, right? But you can go hunting without a parent or guardian or an accompanied someone that's not a minor, an accompanied person that's over 18 or 21. You don't need that. You could be 14 years old and go hunting with your rifle or shotgun with your hunting license or target shooting, right? And be within the bounds of the law and even federal law, right? So, and one of the things that we know that is out there is that there's some provisions once you turn 18 that you can't buy a handgun yet until you're 21 through a dealer with the NICS check, but you're still lawful to own one. So there's some things that are going to change there with 594. So as far as minors with firearms, if the parents or guardians or someone in their guardianship gives their permission, you know, they can be pretty much about anywhere that they can lawfully be and use those weapons. And one of the big things that's important right now with the way that the RCWs are read, with RCW 9, I guess it's 9A 16020, is use of force for basically self-defense. So if you keep your firearms at home and you have a teenager or an 8-year-old or whatever it is, whatever age you think that is valid to leave them home alone, and they need to use those weapons and they have access to them and you've given them permission, that's not at all against the RCWs. If they're on their property, if they're in their home, then hey, that's not a problem at all for them using it for self-defense. It gets a little sketchy as a minor when you're talking about out in public, but on their own property, I guess it says residence in the RCWs. So no problem with minors doing that, but as we will see in 594, that changes. Now 594 specifically, we've been told it's about background checks, but more than anything, it's about transfers. And it says that you don't need to have a background check when you have a gift between immediate family members, but we'll see where that pops up later. And it doesn't cover transfers as far as going to the range or going plinking or whatever. Anytime you want to change that possession, later it talks about it being a bona fide gift. So the transfer is an intended delivery. I hand it from one person to another, right? And that's on all sales or any time you're handling it between unlicensed persons. There's a couple exemptions. The antique firearm is kind of a dummy one because really it basically means that the gun does not function and does not shoot because of their definition of ammunition. That you'll have to look up earlier. But there we're talking about you could give a transfer to an immediate family member is really only good for a bona fide gift, right? So I have to give it to that person intending to make it a permanent change of ownership. I can't just hand them the weapon. You know, it's like, oh, a bona fide gift. I don't think that's going to fly with the attorney generals. If they say, oh, I just handed in the weapon, here's a gift, and I'll get it back. I'll gift it back to you. That's not going to go very far. The other thing that they do give you is that that you can do a temporary transfer to prevent imminent death or great bodily harm. So if you're incapacitated and someone of your party needs to shoot the guy that hacked you up, that's okay, as long as he gives it right back to you, right? Because that's what it says in the law in 594. So some other exceptions, law enforcement agencies and federally licensed gunsmiths. I got a question out there for those of you that are chiming in. Somebody tell me, are there gunsmiths out there that are not federally licensed? Maybe it's just easy for them to do so, but I have a sneaking suspicion that there's some holes there that they are wanting to cover up for some people that operate outside of a situation that they'd like. So as far as transfer between spouses and domestic partners, this is only good if you're using a range gun, because it has to be kept at all times at the range, or it has to be where there is an organized competition, right? And yeah, I don't know how good that is, but most of the competitions that I go to, you cannot share a weapon during competition. So maybe you can plink afterwards. Not sure about that. Here's the kicker for the minors, right? Under 18 years of age, you have to be under direct supervision now. In the old laws, or rather as the law is currently constituted, once you hit 14, you've had your hunter safety and you get your hunting permits, then anywhere that you're lawful to be and lawful to shoot, because even now out here in places in rural Pierce County, even though that we're outside of the city of Tacoma in unincorporated Pierce County, it's still a no-fire zone. So I can't just go out and shoot in my backyard. You have to go down out past 300 to get there now, and that'll probably change soon. But what this does is with minors now, they have to be accompanied by parents. So you get an exemption for hunting with minors as long as they're licensed, as long as they're hunting legally, and as long as the person that is with them is lawful to possess arms, is basically what it amounts to. So the last exception, as far as inheritance, whether it's to minors or whoever it is in the family, that registration aspect still comes back in. And it's not really an exception because they still have to do the check on the background. And see, they either have to have lawfully transferred it or they have contacted the department to notify. And it would be nice if we could just send them a notarized letter through certified mail. I'm not thinking that's going to fly. That's what I read, but I'm sure somebody's going to do some rulemaking when they get a hold of that. So even though it's really an exception for gifts, it's not, because they want it to go in the registry. So many things flying around out there with 594, but this is a huge one. So, you know, if you are comfortable with sending your children alone hunting, this is going to change that. If you're comfortable with sending your kid with a family friend or some other adult and letting them go hunting that way, not possible under 594. Major game changer. I'm Owen Welling. This is Gun Rights Across America, Washington State. I'm urging you to vote no on I594. Tell these 1% gun grabbers like Bloomberg to suck it. You couldn't take the sodas away from the people in New York State. Our rights are not for sale. So we want to say no to 1% bullies. Thank you and good day.